Namaskara. I want to discuss with you one important aspect of law. I discussed with several advocates, but not many people seem to be aware of this particular class, the Cr.P.C, which has been introduced in 2008. Now, a case is being heard in one of the criminal courts in Bangalore. The case was filed in 2011 for outraging the modesty of a female. Now it is 2019. The case is not proceeding. So the victim was of apprehension that the government is not doing enough, they are not fighting enough to prosecute the accused. The case is not proceeding on the lines which she might appreciate. What happens? The victim would want the case to be finished early and they want punishment for the accused. Especially in the case of females, when there is either a sexual harassment case or outraging of modesty or a domestic violence or whatever it is. Now the victim complains to the police station. The police people do the investigation and then they file a charge sheet in the criminal court. Subsequently, the case is supposed to progress and the government allots a public prosecutor to handle this case. In most cases, people are not satisfied with the performance of the public prosecutor for whatever reason it may be, true or false or imagination, or you are expecting too much from the judiciary or the processes that are involved, whatever. In that case, what is to be done? Is there no way out? So in this case I was referring to, the judge, this lady wanted another advocate to be handling her case. So she asked another advocate to present himself. So when the advocate went and presented himself, the judge returned the wakalat telling he cannot accept a wakalat. Instead, application can be given under section 301 of the Cr.P.C. And if the public prosecutor does not object, then he might accept the application and allow the victim to have her advocate, but who will assist the public prosecutor and do as he says. So the question here is, if a victim is dissatisfied with the processes or the progress of the case, even appointing another advocate, even taking the assistance of another counsel, does not solve the problem because he has to work under the public prosecutor. According to section 301, he is supposed to assist the public prosecutor, cannot give written statements, cannot raise objections on his own. It doesn't serve any purpose. And there's another section 302 where the objection of the public prosecutor may not be required, but it is at the discretion of the magistrate to accept the application or not. So these are the two classes of Cr.P.C. under which one could try to have their own advocate in case of dissatisfaction, but that is subjected to certain conditions, again which may not give much of a benefit. This was brought to the notice of the Law Commission, and the Law Commission submitted a report in 2008, and one of the recommendations was that the court, provided that the court can permit the victim to appoint his or her own advocate, who is entitled to run the case on his own steam. He can file objections, he can file he can file written statements, he can raise issues, he can argue the case, submit his arguments with the final argument situation, but after the public prosecutor finishes his arguments. Which means, wherever the public prosecutor has missed a point or has not stressed on a point, now you have an opportunity to have your own advocate and raise those issues, so that the prosecution is complete and no stone is left unturned to ensure that the accused will get punished and the court will be satisfied in doing its job. Now this is a very, very valuable case, valuable section, which unfortunately I find is not being put to use. This matter was taken up in the Supreme Court telling that this clause not acceptable. And the accused took up the matter to the Supreme Court. Then the Supreme Court has very clearly stated, under this section 24, subsection 8, the amendment made giving the court the authority to permit a independent counsel on behalf of the victim or the complainant. And such an advocate or a counsel has got the right to fight the case independent of the public prosecution. He is not going to be subservient or subordinate or assisting the public prosecutor. He can handle the case by himself as if he is an independent counsel. He will assist the prosecution, which means the court, and not the public prosecutor. This is a huge clarification with a lot of ramifications benefiting the complainant or the victim of circumstances. So my dear friends, this is something which we have to utilize in the court. All those people, victims, complainants, who feel that the court is not doing enough or the public prosecutor is not doing enough, which is normally the case, which people believe, you have got a right to appoint your own advocate under section 24, subsection 8 of the Criminal Procedure Code, or Cr.P.C as it is being called. And this amendment was introduced in 2008 and became a law 31st December 2009. Though after that it has not been put to much of use because people were not aware of the latest amendments. So my dear friends, I thought this might be useful to others and therefore fit enough to discuss on the public domain via social media. So the victims now have a right to appoint their own advocate without the interference or the objection of the public prosecutor. The law has provided this, and very rightfully so. We can make use of this, and let us hope that the accused does not get away because some people are obliging the accused. Finally, there is a clear provision that if you are dissatisfied, you can have your own advocate and get to fight the case as you may wish to. Thank you. Namaskar.